Welcome to my YouTube channel. Let's Know Law. Myself, Maninderjeet Kaur Boparai. I hope you all are fine and doing well in your lives. So today I am here to discuss a very important judgment with you all, that is KANTI, BHADRA, SHAH and another versus State of West Bengal. Its citation was 2000 SCR 27, Appeal number 5 of 2000, that is criminal appeal number. So there were two parties involved in this case, petitioner and the respondents. In the petitioner side, there was KANTI, BHADRA, SHAH and another person, and in the respondent side, there was State of West Bengal. This judgment was delivered on 5th of January 2000. Bench comprises of Justice KT, Justice Thomas and Justice DP Mohapatra. So, as you all know, every judgment involves around the facts in issue. So in this case, the facts in issue are whether the trial court should write an order showing the reasons for framing a charge. Facts of the case are as: on the basis of a complaint lodged with the police station, Bura Bazaar, Calcutta, an investigation was conducted by the police and the charge sheet was filed before the Metropolitan Magistrate, Calcutta, against appellants and some other persons for offences under section 454, 380 and 120B of the Indian Penal Code. The magistrate issued process to the accused, and after hearing them, a charge was framed against them for the said offences. While framing the charge, the magistrate had, as per order dated 6th of March 1999, dismissed the petition filed by the accused for discharging them. Appellants thereafter moved the High Court for quashing the charge. So, the Metropolitan Magistrate who framed the charge opted to write a short order, presumably for dismissing the petition filed by the appellants for discharging them. The magistrate stated in the order as: the investigating officers has submitted charge sheet against the 4 accused persons after completion of the investigation under section 454, 380, 120B of the IPC. Hence, prima facie, the case is established against the accused persons under those sections. There is nothing on behalf of the accused persons save and except a petition. So, a further step was taken by the accused person in the form of revision petition in the High Court. Appellants approached the High Court to quash the charge framed against them by a Metropolitan Magistrate. A learned single judge of the High Court, who set aside the first side order, remarked that it was not discernible from the order of the magistrate that he had taken into consideration the charge sheet and other papers submitted therewith for satisfying themselves as to whether there is a prima facie case against the accused persons for the aforesaid offences. This is what the learned single judge of the High Court observed. He said that it is true that the language in which the impugned order is passed is not a happy one, that he is not sure whether the learned magistrate applied his mind to the facts and circumstances of the case and took the pain to satisfy himself from the materials disclosed by the charge sheet and other papers submitted therewith as to whether a prima facie case was made out against the accused persons for framing charges under the aforesaid penal provisions. After observing, thus learned single judge of the High Court expressed his helplessness in supporting the order framing charges against the appellants. The Metropolitan Magistrate was thereupon directed to pursue the charge sheet along with other papers submitted to him and satisfy himself again as to the existence of a prima facie case against the accused person. The further direction given by the learned single judge of the High Court are: the single judge of the High Court said, if the magistrate decides to frame charge upon such satisfaction based on perusal of the charge sheet and other papers submitted therewith, the learned magistrate must record the fact of such perusal and his satisfaction. Only then he shall proceed to frame a charge. If on the other hand, upon perusal of the aforesaid documents, the learned magistrate finds that the papers do not disclose any prima facie case against the petitioner for framing charges, it shall be open to him discharge the petitioners from the case. So in the end, the High Court quashed this order, but directed the magistrate to consider again whether the same charges could be framed against appellants afresh. Now, the Supreme Court held that we wish to point that if the trial court decides to frame a charge, there is no legal requirement that he should pass an order specifying the reasons as to why he opts to do so. Framing of charges itself is prima facie order that the trial judge has formed in the opinion. Upon consideration of the police report and other documents, and after hearing both sides, that there is ground for presuming that the accused has committed the offence concerned. Supreme Court has referred section 239 and section 240, 245 and 227 of the CRPC. Chapter 11 deals with provisions for trial of warrant cases instituted on police report. Section 239 reads thus: when accused shall be discharged, if upon considering the police report and the documents sent it with under section 173 and making such examination, if any, of the accused as a magistrate thinks necessary, and after giving the prosecution and the accused an opportunity of being heard, the magistrate considers the charge against the accused to be groundless, he shall discharge the accused and record his reasons for doing so. So, the Supreme Court said in its observation that the said section shows that the magistrate is obliged to record his reasons if he decided to discharge the accused. The next section, that is section 240, explains that if upon such consideration, examination, if any, and hearing, the magistrate is of opinion that there is ground for presuming that the accused has committed an offence triable under this chapter, which such magistrate is competent to try and which in his opinion could be adequately punished by him, he shall frame in writing a charge against the accused. The charge shall then be read and explained to the accused, and he shall be asked whether he pleads guilty of the offence charged or claimed to be tried. It is pertinent to note that this section required a magistrate to record his reasons for discharging the accused, but there is no such requirement if he forms the opinion that there is ground for presuming that the accused had committed the offence which he is competent to try. In such a situation, he is only required to frame a charge in writing against the accused person. Even in cases instituted otherwise than on police report, the magistrate is required to write an order showing the reasons. Only he is to discharge the accused. This is clear from section 245. As per subsection 1 of section 245, if a magistrate, after taking all the evidence, considers that no case against the accused has been made out which, if unrebutted, would warrant his conviction, he shall discharge the accused. As per subsection 2 of section 245, the magistrate is empowered to discharge the accused at any previous stage of the case if he considers the charge to be groundless. Under both subsections, he is obliged to record his reasons for doing so. In this context, it is pertinent to point out that even in a trial court before a court of session, the judge is required to record reasons only if he decides to discharge the accused. But if he is to frame the charge, he may do so without recording his reasons for showing why he framed the charge. Supreme Court further observed that if there is no legal requirement that the trial court should write an order showing the reasons for framing a charge, why should the already burdened trial courts be further burdened with such an extra work? It observed that the time has reached to adopt all possible measures to expedite the court procedures and to chalk out measures to avoid all roadblocks causing avoidable delays. Further, the Supreme Court observed that if a magistrate is to write detailed order at different stages merely because the counsel would address argument at all stages, the snail-paced progress of proceedings in trial courts would further be slowed down. So the Supreme Court further expressed its views that firstly, it came across interlocutory orders of magistrate and session judges running into several pages. It appreciates if such a detailed order has been passed for accumulating the proceedings before them, but it is quite unnecessary to write detailed order at other stages such as issuing process, remanding the accused to custody, framing of charges, passing over to next stage in the trial. So it is salutary guidelines that when order rejecting or granting bail are passed, the court should avoid expressing one way or other on contentious issues, except in cases such as those falling under Section 37 of the Narcotic Drugs and Psychopathic Substances Act of 1985. Further, the Supreme Court expressed its view on action taken by the High Court. In the present case, as the Metropolitan Magistrate has chosen to frame the charge, the High Court, when moved by the accused for quashment of the charge, could have re-examined the records to consider whether the charge framed was sustainable or not. If the High Court decides to quash the charge, it is open to the High Court to record the reasons thereof. The present order of the High Court is one of the setting aside the charge without any stating any reason, but the direction to the magistrate to consider the materials once again and then to frame a charge for the same offence is simply to repeat what the Metropolitan Magistrate has done once at the first instance. So the Supreme Court said that to ask the concerned magistrate to do the same thing over again is adding an unnecessary extra work on the trial court. Be that as it may, the state has not challenged the order of the High Court. Hence, the Supreme Court did not set aside the impugned order of the High Court. The Supreme Court leave the order as such by making the first set of stated observations. Supreme Court leave it to the Metropolitan Magistrate to exercise his functions under Section 239 or 240 of the Code as he deems fit in the light of the observations made above. So, appeal is accordingly dismissed. And thank you so much. If you like my channel and like this knowledge of the CRPC judgment, please like and subscribe my channel and share as much as you can, and thank you so much. Take care.